Hi, I'm Kayla Kristensen and I'm a lawyer with Robertson Hyetts working in the employment law team. In my last two videos, I talked about what makes a dismissal unfair and who is eligible to make a claim. Today, I will be focusing on how to make an unfair dismissal claim and what happens next. So, once you have determined that your dismissal was unfair and that you are eligible to make a claim to the Fair Work Commission, you need to file your application with the Commission using the Form F2. This form is available on the Commission's website and either you or your lawyer can fill it in. You will also need to pay a filing fee of $74.50 when you submit your application. You'll need to provide you and your former employer's details and explain why you think your dismissal was unfair. You should also include any emails or letters from your employer about your dismissal. Lastly, you'll need to include what outcome you're looking for from your claim, which may be compensation or reinstatement into your old job. Once you have filed your application, the Fair Work Commission will send a copy to your former employer, so keep this in mind when you're filling out your application. Your former employer then has 7 days to provide its response, which will generally outline why they think your dismissal was not unfair and their version of what happened. Your former employer may also raise a jurisdictional objection, asking the Fair Work Commission to dismiss your application, which may be on grounds that you were not dismissed, or your claim wasn't filed within 21 days, or you don't meet the eligibility criteria. This could be because you weren't employed for the minimum employment period, because you earn above the high income threshold, because you are a casual employee who is not eligible to make a claim, or because your dismissal was a case of genuine redundancy. If your former employer raised a jurisdictional objection, the Fair Work Commission may look into this before or during the conciliation. If the Fair Work Commission agrees with your former employer and upholds the objection, your application will be dismissed. In our experience, jurisdictional objections are usually discussed as part of the conciliation. The next step is for the Fair Work Commission to organise a conciliation over the phone between you and your former employer to try and resolve the matter. Conciliation is a voluntary process, and if either you or your former employer don't agree to participate, the matter will be listed for a hearing at the Fair Work Commission. The conciliation is run by a conciliator from the Fair Work Commission, and they are impartial and they will not take sides. They can't assess the strength of your claim, and they can't make any decisions for the parties or impose any settlement on the parties. They will work with both of you to try and reach an outcome. You can attend the conciliation on your own with a support person, or you can ask the Fair Work Commission's permission to have a lawyer represent you. If the parties reach an agreement at the conciliation, the Fair Work Commission will prepare terms of settlement for the parties to sign. This will document the agreement reached between you and your former employer. An agreement may include that you will be paid a monetary amount and/or that your dismissal will be recorded as a resignation, which may be helpful for you and any future employment. Your former employer may also agree to provide a written statement of service. Usually, the terms of settlement will also state that you will discontinue your unfair dismissal application and agree not to bring any future claims against your former employer. It is also very common to have mutual non-disparagement and confidentiality clauses, so it's important to keep in mind that if the matter settles, you can't talk about the outcome with others later. If the matter settles at conciliation, your unfair dismissal application is finalised and you can apply to have the filing fee refunded to you. If your matter doesn't settle at conciliation, it will usually be referred to the Fair Work Commission for a hearing or a conference, and a member of the Commission will make a decision about your case. This is a more formal process than conciliation, and to prepare for the hearing, you and your former employer will be required to file submissions setting out your argument and submit witness statements if you want the Commission to hear from any witnesses. At the hearing, evidence is presented and both parties can question witnesses and make submissions about their case. It's a bit like going to court. You can represent yourself, or you can ask the Fair Work Commission for permission to have a lawyer represent you. Engaging a lawyer throughout the process can often take the stress out of it and can be a worthwhile investment. The Fair Work Commissioner will hear all the evidence and submissions and will make a decision about whether or not you were unfairly dismissed, and if so, they can make an order on what remedy should be awarded to you. This decision is binding on both parties and may be made either on the day of the hearing or at a later date. The decision will also be published on the Fair Work Commission's website and made public. If your claim is successful at hearing, the remedies available under the Fair Work Act include reinstatement to your old job, compensation up to 26 weeks of your usual pay, and other non-financial remedies such as a written statement of service. Once your claim has been heard by the Fair Work Commission and a decision made, your claim comes to an end. Thank you all for tuning in, and I hope you have found this video series helpful. As always, if you think you have a case for unfair dismissal, please feel free to give me a call so we can have a no obligation chat about your situation. Thank you.